right, let's go to our very last one. Calling the matter of Stephen Singer, case number P104624. Good morning, Ms. Deeter. Good morning, Ms. Singer.
Morning.
All right. I went back and read a whole bunch of stuff last night, mostly what was filed by Ms. Singer, Ms. Deeter, and I have some concerns. And I understand your argument that she filed this into the probate matter and not into the trust matter, but to the extent that both of them are before me, I really, at the end of the day, she could have filed it into the other one. And I don't so much have concerns about the motion that is before me right now, which is the motion regarding to Mr. Woloson, and then your motion to strike improper pleadings related to trust administration and having it filed in the probate matter. But I do have concerns with the accounting. But Ms. Singer, that doesn't take you off the hook either. So I just want to go through everything that I read last night, because I spent quite a bit of time reading everything, and just bring up my concerns. And I think that what is ultimately going to happen here is I'm probably going to end up having an evidentiary hearing, and I'm probably going to order a independent accounting be done on this case. So first of all, one of the things that I wanted to note, that in the order which named Ms. Bonenkamp as the guardian of the person and the estate, it states in that order that he is a danger to himself and others and cannot manage his own affairs. That was as of March of 2016. One of the things that Ms. Singer states is that he could have been taken care of in his home, and that he was living with her, and that everything would have been fine. However, Ms. Singer, based on the records that you submitted to this court that were specifically from Lou Ruvo and the Timothy West, according to the medical records, and this was from 7/15 of 2013, he was living in squalor and neglect until Robert started helping him, and Robert was the person with Angels. And he told Mr. West that his daughter was living with him until recently, but was poor care for her dad. And his brother was the one that got him the care from visiting.
That was Natasha. That was Natasha that was living with him at the time, not me. I just want to make that clear.
Okay, so Natasha was living with him?
Yes, when they were talking about he was living in poor squalor and all of that stuff, that was not me living with him. I had tried to move him in with me before that. Lenore and Natasha refused. Lenore was supposed to move him in with her. She bought a house using his bank accounts, and then she refused to move him in with her. Natasha ended up moving in with him and destroyed his entire condo. It was a mess. Her cats, it was disgusting. And I have several emails that I also submitted proving that, with evidence showing that I had asked her several times to clean up my father's home. I got him brand new carpets. I painted his walls. I tried to request Lenore and Natasha several times to come and help me clean his condo up, so that he didn't have to live in squalor. I got him a maid from one of my clients. I had them clean his house regularly.
Okay. All right.
Today's also my father's birthday. I just wanted to mention that. It's been 2 years since I've seen his face.
Okay. Okay. Well, the state, the site that you state in the trust, that except for willful misconduct, gross negligence, bad faith, or reckless indifference, that needs to be proven, not just alleged. And it was not a violation of the grantor's wishes to be placed in the nursing home when there was evidence that being cared for at the home was no longer feasible. As far as the, Ms. Singer, I don't need you to speak right now. Thank you. As far as the guardianship went, I did have a question for Ms. Deeter. Did they have to do yearly guardianship accountings to the guardianship court, Ms. Deeter? Because I know that it was loosey-goosey up until we changed the statutes, and then it got a little tougher.
So that was the issue with the initial guardianship order. It was guardianship of the person, and I know that's one of the issues that Ms. Singer's disputed throughout this, but the order was person only. I believe the title was wrong, and then I think it was the second page of the order that it was Judge Steele at the time had crossed out the estate portion, but it was never a guardianship of the estate. Because the assets were under the trust, the court never took jurisdiction of the trust, and frankly, all of this was before some of the laws changed and giving notice of things like intent for fees and all of that regarding trusts and the court taking jurisdiction of the trust, and frankly, Judge Steele was not overly ever inclined to take jurisdiction. Just something else to point out, since you brought up the nursing home issue. While it was not memorialized in an order, there is a minute order from March 8th, 2016 in the guardianship that confirms he is supposed to remain at the current facility.
Right.
So to the extent issues are being raised about his care, whether his care was appropriate, that was something that the guardianship court weighed in on, and certainly our position is that any recourse or concerns should have been addressed in the guardianship while he was alive.
Which
there were annual...
I agree with you on that. So what I'm going to say as it pertains to that, Ms. Singer, as it pertains to your statements contained in your accounting records that you believe that the money from the nursing home needs to be refunded back, that will be denied. And the reason for that is because the guardianship court specifically had an order that said that he needed to stay in the nursing home, and any action that you would have wanted to bring should have been brought back then. And at this point, the statute of limitations has run on that issue, and so I'm not going to go back and undo that. But again, Ms. Deeter, I'm quite frankly concerned with some of the allegations that are being made by Ms. Singer, and based on the accounting that she put forward, and I know that we're not doing the petition to approve the accounting. Her hearing is not until May 25th, but it's...
And actually, it was my understanding, I'm sorry, that those had all been consolidated to today. She had filed another accounting which was set for May 25th, but in our original briefing, it was my understanding we were set for April 20th, and then we were moved to the 27th because you were gone.
Right.
But it was my intention to argue those today.
All right. We can go ahead and argue them today, but I can tell you that I'm leaning on the side from with what I've seen based on her accounting that she put forward, where she has an actual accounting firm, and it doesn't look like all of the records have been provided. I'm inclined to grant a separate accounting be done by a separate firm, and for the trust to pay for it. That's what I am inclined to do at this juncture. But I will let you argue. Now, that being said, Ms. Singer, as it pertains to Mr. Woloson, he's not currently representing Natasha and Lenore. And there was no adversary process until you decided to bring an adversary process with your sisters. So at which point Ms. Deeter became counsel. So the rules regarding that and your whole thing of conflict of interest are not applicable at this juncture. And so your motion to disqualify Mr. Woloson, which the court already previously denied, is going to be re-denied. There's no current conflict. I don't believe that you have standing to bring that, and therefore, I'm not going to grant that motion. But I am inclined, like I said, I'm going to hear both of you out, on the accounting issues, but I am inclined at this juncture, based on what I saw from Ms. Singer, to order an independent accounting to be paid for by the trust. But, Ms. Deeter, you may proceed.
If you would be inclined, Your Honor, if you would like to go over your concerns, I think it might be more effective to respond to your concerns versus just giving you a blanket argument, if you'd be open to that.
Oh, well, I mean, I'm concerned about you know, like I said, as far as it goes to the nursing home fees, we're not revisiting those. But it looks like there's amounts that were indicated by the accountant that Ms. Singer brought forward. It looks like there's discrepancies between the two accountings that there's no backup documentation for, and I haven't seen backup documentation that Ms. Singer has pointed out that we don't have. So those are my concerns, is it doesn't seem to be complete from your end, Ms. Deeter.
Okay. Thank you for for weighing in. I believe this was I believe the most comprehensive written address of this is in our April 1st objection to Ms. Singer's accounting, and we did spell out, I believe the accounting between our office and between the CPA firm, frankly, is very close as far as total income and expenses. The differences between those are rather close, and if you'll bear with me. As far as a net loss, our total was approximately $99,000. Theirs was approximately $97,000. So we're looking at a difference of $2,156.18 regarding our total overall income and expenses. I think the bigger issue is how the expenses are categorized, and that's really where the difference lies in between the accountings. Frankly, some of it my clients will not be able to account for because there was a period between 2015 and 2016 when Ms. Singer was in control of the accounts. And frankly, that's where the differences are between Ms. Singer's representations and my client's representations. Even if an independent firm addresses those items, I don't know that, you know, there will ever be clarity, and frankly, it will probably boil down to testimony as to what those are.
All right.
Let
me interject, Ms. Deeter, then. The stuff that happened in 2015, 2016, how much did that amount to? Refresh my recollection.
So we had attached as Exhibit E to the April 1st objection, there were $6,588.92 that were partially unknown, that reconciling between Ms. Singer's accounting and our accounting, we had updated those, and that's our Exhibit E.
Okay.
After taking that out, there's $1,052.05 in truly unknown matters that we are not able to account for. There are some checks, there's a charge to Justice, there's a charge to Desert Gym Cats. These are items that my clients are inclined to believe that Ms. Singer made, but frankly, for $1,000, it's not worth fighting over. Based on how you've interpreted the trust previously as well, you've made it clear that any health, education, maintenance, support, and so it's not worth the expense.
Gotcha.
The other largest discrepancy between the accountings and the unknown is we believe that the Raven CPA firm had mischaracterized the $53,000 overpayment to Ms. Singer as part of those unknown transactions. And so once you subtract out that, that's how we get to the $6,588.92 that we clarified, as well as the $1,052, and that accounts for those discrepancies.
Okay.
And I think that really boils down to all of the large differences between the accountings. Certainly, you know, if another firm needs to have the final say, you know, we appreciate that, but we did spell out those discrepancies, and I think Ms. Singer's accounting was more of an effort to recharacterize and show that that was an unknown transfer when it was really known, to reduce the liability potentially against her for those funds. Again, the overall income and expenses are extremely close. Our total expenses were characterized as $679,000. Their total expenses were $678,941. And so, again, by the time you get to the differences, they're so minute that we do not believe that it would be a cost-effective use of either attorney time or additional CPA or other firm time to figure out a few $1,000s in expenses.
What about Ms. Singer's, and taking aside, because as I've already said, I'm not going back with the nursing home charges, but what about Ms. Singer's argument that the expenses should not have been, that certain of those expenses should not have been incurred? Other than the nursing home.
And if you'll bear with me, she has filed many things.
I understand.
One of the claims was elder abuse, and denying expenses for that. She really hasn't made any specific allegations aside from the $3,000 to Lenore. We did address that in the April 1st opposition as well, okay, which was an agreement. They had come to an agreement. There are emails confirming the agreement, that she agreed to reimburse attorney's fees, and that she had used funds to CarMax for $1,800 to reimburse her own attorney's fees in the guardianship as well. So to the extent that the $3,000 were used, it was a reimbursement, which Ms. Singer had acknowledged that she was in agreement with at the time. And frankly, everything else was used for his care, which I believe is set forth in the accounting.
Okay.
We had explained the other discrepancy, which you had previously raised with the Bank of America distributions and why there was a difference of $16,700. We did explain that in the April 1st objection as well, that $4,200 was reimbursed to Lenore for attorney's fees. $12,500 went to Mr. Woloson's trust account. We did submit receipts for that with the April 1st filing as well. And so I think a lot of the things that Ms. Singer raised are simply, they're red herrings, and frankly, it all goes back to 2015 and 2016. Okay. Once my clients took over the accounts, I believe the accounting shows that all of the expenses went to Mr. Singer's benefit, and the issues that Ms. Singer has raised are truly during the guardianship time period, and that is really the only time period that my clients have not been able to, with 100% accuracy, verify the transactions.
Okay. Thank you, Ms. Deeter. Ms. Singer, go ahead.
Okay, so that's a lot there. First of all, the only reason that the transactions that we're talking about are from 2015 is because 2016, Lenore and Natasha stole all of the accounts from
Ms.
the
Singer,
trust and put them into their own personal account.
Ms.
Yeah.
Singer,
Yeah.
I want you to stop using pejorative terms such as stole. I want you to stop using pejorative terms such as lied. Just stick to neutral words and make your argument, okay?
Okay.
Thank you.
Transferred, can I say transferred?
You certainly
funds transferred from funds from the trust account into their own personal accounts. And that is why they are the only ones that have the accounting and the statements and, that nature. Even the statements that they put forth, and they said, so let's just use an example, the $6,582 or $88.92 that Ms. Deeter mentioned, $3,000 of that was a check that Lenore wrote to herself and endorsed to herself that she blamed on me. It wasn't where she spent the money that was the issue. It was the fact that she tried to incorrectly say that I used the funds instead of what was correct, that she had used the funds. Ms. Deeter mentioned that there was a difference between $99,000 and $97,000, and then after the $53,000 bank error that there's only $1,000 left over. That math is incorrect. The $53,000 did not come until after the bank error, so that had nothing to do with what the accounting was, because those funds don't play in that. Yes, the funds that are left over, they can be taken and given back to Bank of America. No problem with that. But those are not funds that were original accounting. Bank of America accidentally paid those funds to an account, and then they were reimbursed, right? So that account is at zero, regardless of what happens with money afterwards. That was not in the original accounting, is all I'm trying to say. It had nothing to do with that $53,000. I feel like that was a red herring. But I would definitely appreciate an independent accounting source. I have said that from the very beginning. Even in 2015, when we were arguing the guardianship, I said that it should either be an independent person monitoring the accounts, or that all three of us should be on that accounting. The judge in the guardianship agreed with me, and even though Lenore was only granted person of the estate, she still transferred all of the funds. She was only granted guardian of the person, not the estate. She still transferred the estate into her own personal account. She transferred the condo out of the trust, all of the funds out of the trust except for the life insurance, which she also attempted to do, but the life insurance company, their attorneys denied that because they correctly identified that she was only the guardianship of the person. I apologize for my words. I appreciate, because I recognize the fact that you probably have had hundreds and hundreds of files to go through, not to mention the hundreds that I have submitted to the court. And I apologize for that, but I felt like over the amount of time, 5 years, there was a lot of evidence to provide, and I wanted to make sure that the court was able to see and hear all of it. I think that having an independent evidentiary hearing is the right thing to do, to put all of the evidence forward and to decide the truth based on the evidence that is presented. I think that is the only fair thing to do. And like I said, I really appreciate that this court took the time to go through the evidence and read through the paperwork. I know that it was a lot, but I think that my dad deserved justice. He did not want to be put in a nursing home. He wanted to continue to live with me. And even though the guardianship court said that he should stay there, when they asked my father what he wanted, all he said over and over again was, "I just want to see Karina. I just want to see Karina." And he was denied that. The elder abuse comes from Lenore denying my father medical care when a doctor recommended it. He was in the nursing home. The doctor said, "We need to take him to the hospital. He is not doing well." Lenore denied that. That is what I have submitted for evidence of elder abuse. Also, the fact that in the trust, he stated that if he was to be put in a nursing home, he wanted extra care. He had the money. He worked hard his entire life. He had the money to provide it. And Lenore refused to provide it. She took away his television multiple times. She refused, even after Lenore knew he was being abused at the Wentworth, she sent him back there for another 2 months because she didn't want to end the contract, which would have ended up being another $200 a month, yet is willing to pay her attorneys over $100,000 to defend herself in court out of my father's money. The guardianship court said she was not, and I was not, none of us were allowed to take money from the trust in order to pay our attorneys. The fact that Mrs. Deeter said that I used $1,800 to go to CarMax to pay an attorney is ridiculous because the bank statement says CarMax. So I don't know what attorney is named CarMax or how that could have been possible, but that is also another red herring. I think I've addressed everything. I'm sorry, I don't want to waste anybody's time. I just want to make sure that I address all the things that were put forward. Is there any other questions that you have of me, Your Honor, or
just
anything else that you think that I?
If you look at the Avenir records, which you provided to the court, which I did look at, cable TV was included in his package of the $54.95 per month.
He didn't have a television to watch the TV. She took that from him, even though I bought it from him. She took it away from him. I bought him another one, and she refused for the caregivers to put up the TV. I had to go in there myself and put it up.
All right. I haven't decided if I'm going to have an evidentiary hearing, and I haven't decided whether or not I'm going to do an independent, because here's the thing. Having an independent forensic accounting done is very, very expensive, and it's more money that would ultimately come out of the trust if I were to order it. And at this point, your NRS 41.1395, the elder abuse statute, you have to file a complaint if you wanted to do that. And at this point, any actions would be barred by the statute of limitations. So your elder abuse claim is not going anywhere, Ms. Singer. I understand that you're trying to utilize that to bootstrap your argument under the trust for willful misconduct and gross negligence, but it doesn't work that way. So the elder abuse is going nowhere. As far as, let me just, I think the only other issue, there's 3 issues that you raised that I want Ms. Deeter to address, and then I'm going to tell you all what I'm going to do. I already know what I'm going to do, but I want an address on these 3 issues. Ms. Deeter, to the extent that there were funds that were transferred from the trust account to their own personal accounts, you by your own admission admitted that even though the order itself states that it was supposed to be guardianship of the person in the estate, and the one that I saw didn't have any interlineation on it, you indicated that it was only supposed to be of the person. So why did your clients transfer funds from the trust account to their own personal accounts is number 1. Number 2.
I'm sorry, Your Honor, can you hear me?
Why
I think
are
my
we-
screen just froze.
Why did we?
I don't know. That did it by
Oh, okay.
Sorry, you're back.
Yeah, I can hear you now. Our AV bridge was weird. That just taught. Number 2, why the condo was transferred out of the trust. And number
Okay.
3, money that was taken from the trust to pay for attorneys. I know that under 8.8 that it says that they can hire professionals. However, if they're doing it for the purposes of, I don't have a problem with their paying attorneys for the guardianship, but for the purposes of the trust, if they're doing it in an adversarial posture towards Karina, shouldn't both sides pay for their own attorneys and not have those funds come out of the trust? So those are the 3 issues I would like you to address for me.
So as far as the funds being transferred to personal accounts, we did address this in our April 1st filing as well.
Okay.
We've acknowledged from the beginning they did close accounts, and it was as a result of an investigation from a Detective Bruno with Metro.
Oh, that's right.
They were concerned with Karina's actions regarding the accounts. They were then contacted by this detective. Frankly, they're not sure who initiated the case. My clients have represented it was not them, but they were contacted and advised to move accounts.
Okay.
For better or worse, that's what they did. And that's why we've accounted for all of those funds.
Okay.
The majority of the accounting are the funds that were transferred to those accounts, and we've included the transfers. We've included all of that information and accounted for all of those funds.
Okay.
So that is part of the accounting. As far as the condo, it's my understanding Ms. Singer did not sign off on the refinance for whatever reason, but as majority trustees, 2 of the 3 trustees had authority to act, so it was refinanced. It's my understanding it was not an intentional omission to have it removed from the trust. Frankly, it happens with refinances that oftentimes it comes out, and it was not caught that it needed to go back into the trust until Mr. Singer passed away.
Okay.
All of the rental income from the condo has been accounted for and is included in the accounting, and for all intents and purposes, they did treat it as a trust asset, and they accounted for those funds.
Okay.
So, yes, well, technically it is an issue. They have accounted for it, and those funds have not been used for their personal gain.
Okay.
As far as trust fees, during the guardianship, yes, there were fees used to Ms. Cunin. We can submit this email. It has not been filed with the documents, but there was an agreement between my clients and Ms. Singer for payment of attorney's fees. As far as the CarMax issue, the email from Ms. Singer is, we agreed to pay back our attorney's fees out of Dad's estate. I'm sure you see the check for $3,000 that went to Lenore. My attorney's fees have been $2,500 so far. I've paid myself back with $1,800 for my car to CarMax, $370 to Microsoft, and the last $300 I owed to Dad last month for groceries. So there was an agreement then as far as attorney's fees. Since then, the fees were primarily to Mr. Woloson, which again are detailed in the accounting. But again, since things were filed with the court, once Ms. Singer hired counsel, fees have not been paid from the trust. We have filed petitions to approve fees, but at that point, additional fees were not paid as soon as you indicated no additional fees.
Okay.
So it's our position that, it was not adversarial. Certainly there are liens and fees requests by Ms. Singer's attorneys as well, which based on how you've directed, I assume you will approve, but we'll get to that issue. But once this became adversarial in the court, fees have not been paid from the trust.
Okay. Here's what I'm going to do. I have not, quite frankly, I don't know if you all know, I was out on medical leave for basically 3 weeks and just kind of getting back in, and I'm in back-to-back trials. So while I've looked at your individual accountings, I have not looked at them side by side. I'm going to do my own independent examination of this, and then I'm going to do a written order on this, and if I decide that I want to have an evidentiary hearing, I will have an evidentiary hearing. If I decide that there should be an independent accounting done, then I will order an independent accounting, but that will all be outlined in a written order. And the reason that I'm doing it that way, Ms. Singer, is because if I take a look at what you've provided and what Ms. Deeter has provided and look at all of the records and see that it's going to cost more than it is worth in order to do an independent accounting, I am not going to deplete the trust that way by doing that. If it's going to be more in attorney's fees for both sides to have an evidentiary hearing, for me to have you, all the sisters in here, and see whose credibility I believe more. If it's going to cost more to do that, then I'm not going to do that. But I want to because 1 + 1 = 2, right? So I want to do a side-by-side comparison and see what I come up with, and I just have not had, in all candor, I have not had the opportunity to do that. Some of this was, relatively recently filed by Ms. Singer, and so I do want to go back and look at everything again. So I know that everybody wants to get this done, but I think I owe it to all the parties involved to make sure that at the end of the day, because here's what I could do. I could grant your petition, Ms. Deeter, and we have an appeal. Or I could grant Ms. Singer's petition and we have an appeal. So I want to make sure that both sides know that I have done my best to make sure and given my reasonings for why I'm doing what I'm doing, so that both of you can walk away hopefully and accept what my decision is. Okay? So I'm going to take it under advisement, and I've got 60 days, so math sometimes takes me a while, but you'll have it within the next 60 days.
Thank you, Your Honor. We do have the hearing May 25th, which Ms. Singer had said. Okay, thank you.
That one. Okay.
Thank you.
Can I just ask one more thing that, sure. I know you have a lot to go through, Your Honor, but will you also read the email from Detective Bruno that they have provided so you can see exactly who did reach out to who, what came of that, because there wasn't a report done, and what Detective Bruno thought was actually elder abuse was Lenore and Natasha's charges. If you could just, I know you're going to probably read everything. I just wanted to.
I will take a look at that from the perspective of if there was a concern from Metro and they had a basis to move them. Really what I'm looking at is was there a justifiable reason to do what was done? And if there was, is there backup documentation, and does the math make sense? That's what I'm looking at, okay? I know that, Ms. Singer, that you feel that justice was not done for your dad, and unfortunately, there's nothing I can do to bring back your dad, and there's nothing that you can do at this juncture based on our laws and the statute of limitations to bring forward actions that should have been brought a long time ago. So the best that I can do is take a look at the accountings and make sure that it makes sense, and hopefully, like I said, when I'm done, you all will have a decision that at the very least you know that the court has looked at everything and given you a decision that you all can live with. If you can't, then you'll know what your next steps are, but hopefully you'll be able to live with whatever decision I make. Okay?
Thank you, Your Honor.
All right, that's all for today. We stand adjourned. Thank you.